Good morning, everybody, and welcome to today's session on telecommunications leases. Telecommunications leases, not just any other lease, the special considerations that apply to telecommunications leases. Now, we've seen with bushfires, floods, and COVID, the importance of telecommunications and access to telecommunications. And these things are likely to expand the telecommunications network, and with it, the powers of carriers are likely to be enhanced rather than diminished. So this is a timely topic, we feel. Now, my name is David Crease. I'm the head of our property planning and construction team here at Bardia Perry, and I'm going to be joined today by my colleague, Senior Associate Christy Carlisle. Now, Christy is going to talk first, and she's going to talk about an overview of the rights and obligations that carriers have under the Act. That's the Telecommunications Act 1997, and the special considerations that apply when you are negotiating, when landowners are negotiating leases or licenses with carriers. I'll then follow up by reviewing a couple of cases which have considered the application of these powers. Now, just before we get started, let me acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land from which I'm broadcasting, and pay my respects to the elders past, present, and emerging. So just before we begin, a couple of housekeeping items so that you know how to participate in today's event. You'll have the opportunity to submit text questions at any time during the webinar by typing in your questions in the box found on the control panel. So that's the chat box there, so insert your questions there. You can send them any time during the presentation, and we'll look to answer them during the webinar, probably at the end of the presentations. You'll also receive a copy of the slides and recording after the event, and we'd appreciate if you could fill out a short survey on the conclusion to make sure that these presentations are as relevant as they can be to you, our audience. Okay, so let's begin, and to do that, I will hand over to Christy.
Thanks, David. I just wanted to apologise in advance if the rain does get too loud and you're unable to hear me temporarily. It can get pretty loud in the room I'm in, so apologies in advance. And I can't believe it's still raining, and I hope everyone's safe out there. Today we're going to explore the rights and obligations that telecommunications carriers have under Schedule 3 of the Telecommunications Act 1997, which is Commonwealth legislation. We'll also explore what this means for landowners and the special considerations that apply when negotiating leases or licenses with telecommunications carriers. And most of you are probably aware, dealing with carriers can be a pretty painful process sometimes, but hopefully we can provide you with some practical guidance in today's webinar. So what are telecommunications facilities? When we think of them, we often think of the large towers and with antennas erected on them. We've all seen them. We pass by many of them every day, both in the city and the country. They're crucial parts of our telecommunications network. Whilst they can be quite unsightly, carriers have invented some fun ways to disguise the towers or to make them blend in with their surroundings. And we've got a few examples here. This one I'm not sure is located in Australia, but very creative nonetheless. This one, I don't know if you can see on the left-hand side of the window there, the length they've gone to make it a bit less visually impacting. And the one with the palm tree I particularly like. So telecommunications facilities, whilst these towers are often the first thing we think of when it comes to a telecommunications facility, under the Telecommunications Act, the definition of a facility is much broader. It includes any part of the infrastructure of a telecommunications network, and also includes any line, equipment, apparatus, tower, mast, antenna, tunnel, duct, hole, pit, pole, or other structure or thing used or for use in connection with a telecommunications network. The importance of having a reliable and effective telecommunications network in Australia is integral and is reflected in the fact that carriers are given certain legislative rights and powers. This often gives carriers a superior bargaining position when it comes to negotiating leases and licenses. Thus, it is crucial to have an understanding of these rights in order to effectively negotiate with a carrier. The bulk of these rights are contained in Schedule 3 of the Telecommunications Act. Where a carrier can undertake certain activities pursuant to those Schedule 3 powers, the carrier may not be required to comply with particular state or territory laws, including planning and development laws. Broadly speaking, the Schedule 3 powers allow a carrier the right to inspect land, install a facility, maintain a facility, without the consent of the landowner and without requiring the landowner to be compensated, save for in particular narrow circumstances, provided that the carrier complies with the requirements set out in the Act. Those requirements must be complied with before each and every exercise of the Schedule 3 powers, which is often why telcos go to the trouble of negotiating a lease or licence. We will now look at these rights in a little more detail. The power to inspect is quite broad and allows a carrier to enter on and inspect land to determine whether the land is suitable for its purposes and to do anything that is necessary or desirable for that purpose. The Act provides some specific examples as shown there on the slide, including the right to fell and lop trees and to alter the position of services. The power to install a facility under Schedule 3 is somewhat more limited and can only be exercised, number one, where the carrier has a facility installation permit. Such permit must be obtained from the Australian Communications and Media Authority, with the criteria set out in Clause 27 of Schedule 3. It authorises a carrier to install one or more specified facilities in circumstances where the carrier has not obtained all the administrative authority and approvals required under relevant state legislation. This is often a last resort for carriers as it is not a straightforward process and permits are only granted in very specific circumstances. For example, the carrier has to provide evidence that it has made reasonable efforts to negotiate in good faith to obtain all the administrative authorities and proprietor approvals required for carrying out the installation of the facilities covered by the application. So number two, the power to install can be exercised where the facility is a low impact facility. The minister may make a determination as to what constitutes a low impact facility, and the Telecommunications Low Impact Facilities Determination of 2018 is the current determination. Some facilities are excluded from ever being low impact, for example, certain types of facilities or facilities in certain locations, such as areas of environmental significance and areas with particular zoning. The Act also specifically excludes some facilities from being low impact, including designated overhead lines and certain towers. And the third instance where a power to install can be exercised is where the facility is a temporary facility for use by or on behalf of a defence organisation for defence purposes. So the power to maintain a facility under Schedule 3 is quite broad and includes the right to alter, remove or repair the original facility and the right to replace the whole or part of the original facility in its original location, provided that certain prescribed conditions are met by the carrier. This is the power that landowners should take most notice of. It is particularly relevant in a situation where a facility exists on a particular parcel of land, the lease that was entered into has come to an end, and the parties are now negotiating a new lease. The carrier is in fact entitled to exercise its powers to maintain the facility under Schedule 3 of the Act without needing to have the landowner's agreement to do so. It is often for this reason that a carrier may be in no hurry to finalise a new lease or elects to take a hard line with certain provisions in the lease document. There may be instances where a carrier may cease all negotiations and elect to rely on its statutory rights, where a landowner has been unreasonable in its negotiations to renew a lease. In these situations, a commercial agreement may not be entered into, and the landowner may end up shooting itself in the foot by missing out on any rent payments entirely. Landowners should therefore be as commercial and reasonable as possible in negotiating the terms and amount of rent. So it's also important to understand that there are overarching provisions which a carrier must comply with where it intends to exercise any of its Schedule 3 powers. These provisions are contained within Division 5 of Schedule 3 and include such things as: number 1, giving notice to the landowner and any occupier of the carrier's intention to undertake an activity, specifying the purpose for which the carrier intends to engage in the activity, and giving at least 10 business days notice in most cases before the carrier begins to engage in the proposed activity. Such notice must be given before each and every exercise of the Schedule 3 power. But notice is not required in certain circumstances, including in emergencies and to protect the health or safety of persons or the integrity of the telecommunications network. A carrier must also ensure that it does as little damage as practicable in exercising any of its rights and making good if damage does occur. A carrier has to ensure that the activity interferes as little as practicable with the operations of a public utility, public roads and paths, the movement of traffic and the use of land. And the carrier must act in accordance with good engineering practice and comply with environmental and safety requirements, recognised industry standards, the regulations, codes of practice, and the conditions of any facility installation permit. Compensation may be payable by a carrier where it exercises its Schedule 3 rights under clauses 42 and 62 of the Act, and the landowner has to show that they've suffered financial loss or damage in relation to property. But David will touch on this in some of his case studies. So now I want to turn to a few common issues that you should consider when negotiating a lease with a carrier. We're looking at 8 issues today, but you should not limit your review of a potential lease to only these issues. So number 1 is the definition of permitted use. This is usually drafted very broadly and will include something along the lines of what appears on the slide. Care needs to be taken in relation to this definition. The reference to land is usually a defined term of the lease, which may include the whole of the land on which the facility is built and not just the area being leased. Thus, by referring to the land, you may be inadvertently granting rights to do things on the land outside the leased area. So the use needs to be limited to just the premises. And we recommend deleting the words, including the exercise of any rights as set out in the Act, at the end there, as there's no need for an owner to contractually agree to this. If a carrier has statutory rights, then it can rely on those rights. So number 2 thing to look out for, a license which is coupled with and runs with the leasehold interest. So following on from the definition of permitted use, there will often be a clause in a lease which states that, in addition to granting a lease over the premises, the owner grants a general license to the carrier over the balance of the land, and the license is coupled with and runs with the leasehold interest. This license should be resisted or restricted so far as possible, perhaps by including a plan of the agreed licensed area in the lease. Failing to do so could inadvertently grant a license to use the whole of the land for any purpose, which may affect your ability to deal with the balance of the land in the future. So number 3 is the reinstatement and make good clauses. Commonly, the lease will require the carrier to remove that part of the facility located above the surface of the land upon vacating the premises. This should be resisted, and the carrier should be required to remove all installations, including anything below the surface of the land, such as cables, which could be difficult to determine who the cables belong to in the future and whether they're still live or inactive. We've noticed that carriers will try to limit their obligation to make good below the surface to a depth of 600 millimetres, which may or may not be sufficient given the nature of the facility and where cables have been installed. The carrier should be required to make good to the condition the land was in as at the date of first occupation and not the condition at the commencement date, which will reset each time the lease is renewed or an option is exercised. The carrier should also be required to pay rent until it complies with its make good obligations, because there are often clauses in the lease where a carrier will reserve itself the right to make good over an extended period of time, perhaps 3 months, which is a lengthy period of time if there's no rent payable. So number 4, the assignment clause. The lease will usually permit the carrier to assign the lease, sublet, license, or partner possession of the whole or part of the premises to a related body corporate or another carrier without the owner's consent. The carrier is only required to notify the owner within a period of time after the fact. Carriers usually require this right as they enter into co-location agreements with one another, and these relationships can be complex. An owner is not privy to the intricacies of these relationships, so a carrier wants to have the freedom to deal with its lease interest without owner's consent. In our view, an owner should have control over who occupies its land. We recommend seeking that the carrier obtains the owner's consent to any proposed assignment or subletting, such consent not to be unreasonably withheld, and requiring the carrier to supply certain information so the owner may make a more informed decision. So some other issues are the clause which will deal with subsequent occupiers. So there'll often be a clause in the lease which restricts the owner from granting rights to subsequent occupiers in one of 2 ways. Firstly, where the owner proposes to grant rights of occupancy on the balance of the land to other carriers or occupiers, which include the right to operate radio communications or telecommunications equipment. It would require the owner to give notice to the carrier and obtain the carrier's consent where the grant is likely to adversely affect or interfere with the carrier's permitted use. This can obviously be problematic as it hinders an owner's ability to deal with the balance of the land. Also, the time involved with obtaining a carrier's consent could cause a subsequent deal to fall through. We suggest imposing a time frame within which the carrier must respond, including deemed acceptance if no response is received within that time frame. The clause should also limit the carrier's ability to request information to only that which is reasonably required, and the carrier's consent must not be unreasonably withheld. The second restriction in the clause usually provides that if the carrier establishes during the term that any changes to other carriers or occupants' facilities are likely to adversely affect or interfere with the carrier's permitted use, then upon receipt of notice by the carrier, the owner must, 1, arrange for the other carrier or occupier to modify its facility or the operation of it so that it no longer affects the carrier's permitted use, or 2, arrange for the relocation of the other carrier's or occupier's facility so that it no longer affects the carrier's permitted use, or 3, terminate the arrangement with the other carrier or occupier. This could obviously be problematic if the owner has not considered these obligations when negotiating the lease terms with subsequent occupants of the land. If these rights have not been included into the subsequent occupants agreement, then the owner would be in breach of the first agreement with the carrier, as it is unable to compel the subsequent occupier to take any action to cease the interference. This is also problematic from the point of view of the subsequent occupier, who may obviously have some reservations about including such provisions in its own lease and being held accountable to the carrier's requirements. So number 6, the permits and approvals clause. There'll often be a clause which provides that the owner, number 1, authorises the carrier to make applications to any relevant authority for any necessary permits, consents and approvals to enable the development, construction and use of the facility. And 2, must exercise and procure every right of appeal arising from the determination or the failure to determine such application. And 3, must sign all documents and provide all assistance required by the carrier to obtain the necessary permits, consents and approvals. This can be particularly problematic where a site has become contentious, for example, where it is close to a school or in an area that has received a lot of opposition by residents. The clause should also reserve the right for an owner to have some reasonable input into the nature of the consent, and limited so that the owner is not required to commence or participate in costly proceedings, particularly without obtaining the ability to recover any such costs from the carrier. This clause is also particularly problematic for councils who are landowners, as it could be seen to require the council to fetter its powers as a consent authority by contractually agreeing to do what is required by this clause. Therefore, councils should not agree to such a clause and should ensure that there is a no fetter clause in the lease to make it clear that the council is entering into the lease in its capacity other than as a consent authority. So the next clause relates to the surrender of lease. So carriers often want the ability to terminate the lease on 6 months' notice or some specified period of notice, where factors affect the carrier's use of the premises to the extent that 1, the permitted use is compromised or the premises are no longer required. 2, the level of service provided to its customers falls below the coverage level acceptable to the carrier, or as a result of significant network changes, the facility ceases to operate as part of the carrier's telecommunications network. Or 3, there is an emergence of radio interference or physical interference, which, in the carrier's opinion, materially interferes with the permitted use or the performance of the facility. Depending on the specific drafting of such a clause, it could be a get out of jail free card for a carrier to exit a lease whenever it likes. Although it can be difficult to achieve because carriers are very resistant to amending these sorts of clauses, the owner should try to have the clause worded so that it allows an objective assessment of whether the facility is no longer required, as opposed to it being a purely subjective opinion based on the carrier's views. And perhaps also so that the right does not arise until after, say, 5 years of the term have elapsed. Commercially, owners should factor this in, as a 10 to 20-year lease could end up only lasting a few years if such a clause is included and the carrier is in fact able to terminate. And the final clause that you should be particularly aware of is a waiver of notice under Schedule 3. So one of the most important clauses in the lease is the one which states the owner waives the requirement for the usual notice that the telco must provide under Schedule 3 before exercising its statutory rights. Whilst this may seem acceptable at face value, it requires very careful consideration. This is because the clause will usually operate so that it survives the expiry or earlier termination of the lease. That is, even when the lease comes to an end, the clause still has effect. Given the ongoing nature of such waiver of notice, in a situation where a facility exists, the lease comes to an end and the parties are now negotiating a new lease, the carrier is in fact entitled to exercise its power to maintain the facility under Schedule 3 without giving the usual notice, thus avoiding any ability for the owner to raise any objections. Hence, a carrier may be in no hurry to finalise the new lease, may offer a lower rent than before, and may even cease negotiations if the parties cannot reach agreement. The carrier terminates any holding over, stops paying rent, and then elects to rely on its Schedule 3 power to maintain, and the owner will not receive notices and has no ability to object. Hence, landowners should be as commercial and reasonable as possible when negotiating new lease terms, and must be aware of this seemingly innocent waiver of notice clause. We recommend that it should be deleted, which is not likely to be agreed to, but it should at least be amended so that it is expressed to cease to have effect when the lease comes to an end. So now I'll hand over to David for some further discussion about telecommunications leases and some examples of recent cases.
Good afternoon again, everybody. So I'm going to talk about a couple of recent significant cases, and I should say that these really highlight Christy's comments about how important having an agreement in place with the carrier is, rather than simply allowing the carrier to rely on the carrier's powers under Schedule 3 of the Act. So the first case that we want to talk about is NBN Co Limited and Pipe Networks Pty Limited. So this is a 2015 case in the Supreme Court of New South Wales, and Justice Kuntz was the judge in this case. Now, bit of background, so everybody knows who the NBN is. Pipe Networks is actually a subsidiary of TPG, a fairly well-known internet service provider, and they wanted to install some fibres, fibre to the node type stuff, in apartment buildings. They wanted to put it into the basement or an MDF room in apartment buildings, in part utilising some of the NBN's equipment. But the important thing about this, and which was really the nub of the case, was that they wanted to put it in, and they had to plug their equipment into a 240 volt power socket, which would then draw power from, in most cases, I suppose, the owners' corporation's power supply, and they didn't ask for the consent of the owner or occupier of the apartment building. Now, as you'll recall from Christy's presentation, the carrier is required to issue a LAN, a land access activity notice, to the owner or occupier, and that's what they did. In the LAN, they said that what the activity is we want to install and maintain in-building subscriber connection equipment, which were low impact facilities for the provision of telecommunication services to or for an owner, occupier or tenant of the relevant MDU, the relevant apartment, that is. So the idea was that they would have this equipment in the basement, and if they managed to sign up any of the owners living in the apartment, they could easily connect it directly into the apartment. So what that involved was running an optical fibre from the existing pipe fibre network to the basement, installing telecommunications equipment, being in the communications room, connecting it to in-building copper wiring, which was in turn connected to the individual premises within the apartment building. And as we've already explored, that involved connecting the equipment to a power socket located in the basement for the purpose of drawing power from the power supply to allow this equipment to work. Now, they said that it's a very efficient equipment. It's not going to draw much electricity at all, and perhaps, well, they would say generously, you might have a different view. They said they'd pay the pricely sum of $1 per day annually in advance for the privilege of drawing on this power. Of course, power costs are very much in the news these days, perhaps not as much as it was in the news in 2015. So NBN Co took Pipe Networks to court and to get a declaration as to whether this was permitted under Schedule 3 of the Act. Now, Pipe Networks relied on two parts of Schedule 3. Firstly, Clause 6, which is in relation to installing facilities, and what that clause says in particular is that a carrier may, for purposes connected with the supply of a carriage service, carry out the installation of a facility if, relevantly, the facility is a low impact facility, and if they are authorised by that subclause, then they can, for purposes in connection with the carrying out of that activity, enter the land, construct and place the goods, and do whatever is necessary. Now, Pipe Networks argued that that meant that included, the installation included plugging the equipment in and drawing the power. Now, Justice Kuntz said no, he had a look at Clause 6 and he said no, that isn't what Clause 6 authorises. Whilst it may authorise plugging the equipment into a power socket, it doesn't authorise drawing the power once the equipment has been plugged in. So at that stage, Pipe Networks was only halfway there. So Pipe Networks then turned to Clause 7 of Schedule 6, and Clause 7 relates to maintenance of the facility once it's already there. And Clause 7 in turn says a carrier may at any time maintain a facility, and Subclause 2 says a carrier may do anything necessary or desirable for the purpose of exercising its power under Subclause 1, that is, its power to maintain a facility, including but not limited to, those fairly wide words, including but not limited to, entering on the land, removing or erecting a gate or any fence. Now, you might say, well, drawing power isn't either of those things, but remember it's including but not limited to. So it could be things outside those two named activities. So, and as Justice Kuntz found, so any conduct which makes the proper functioning and operation of the equipment certain is included within that power to maintain, and that's by operation of Subclause 7.3. And what Subclause 7.3 says, that a reference to maintenance of a facility includes a reference to, relevantly, the provisioning of the original facility with material or with information, whether in electronic form or otherwise, and ensuring the proper functioning of the original facility. So that is what Justice Kuntz fixed on. Now, the parties had agreed, so this is NBN and Pipe Networks in the case, had agreed that electricity, after it passes through the apartment's meter, its electricity meter, property or goods, and there was a previous case back from 2003 which had held that was AGL Victoria and Lockwood. Now, that meant that we were talking, so 7.3 talks about provisioning the original facility with material or with information. So it's provisioning the equipment with material that's necessary for its operation. So, as Justice Kuntz found, the drawing of power to the equipment is conduct which ensures its proper functioning. That includes plugging it in, but as we know, they were able to plug it in accordance with Clause 6, but Clause 7 authorised the drawing of the power and plugging it in if it was necessary to bolster the powers under Clause 6, was then plugging the equipment into an available power point is necessary or desirable for the purpose of exercising the power under Subclause 1. And so it's authorised under Subclause 7.2, which you'll recall is that a carrier may do anything necessary or desirable for the purpose of maintaining the facility. So Pipe Networks was successful in those proceedings. You may have a question as to, well, what about this $1 a day? Was that sufficient? Well, Justice Kuntz did also observe, and going back to this question of the electricity being property or goods once it passed through the apartment's meter, and he said, for the purposes of section 42, which is the compensation section or clause of the schedule, that pipe network's use of the apartment's electricity would give rise to financial loss or damage, because the apartment owners would have a corresponding obligation to pay its supplier of that electricity, and that supply of electricity was not something that they had consented to or from which they would derive a benefit. So it was held that for the purpose of clause 42, the compensation would be payable because it would be the use of a physical matter, such as the socket and the electrical wiring. And also, clause 42.2b refers to, has an extended definition of what can be compensated, and that includes the taking of sand, soil, stone, gravel, timber, water, and other things. And those last three words are the relevant words, and other things, because Justice Kuntz found electricity would be an other thing. So not all bad news for the owners of the apartment buildings. Which then takes us to a far more recent case. This is in 2021, and that is Satellite and Wireless Pty Limited and Queensland Bulk Water Supply Authority, trading as Seqwater. So what happened here was Seqwater is a public utility. It had a reservoir in the Alexandra Hills area outside Brisbane, and Satellite wanted to install a low impact facility on the roof of that tower. Now, it said that it had entered into an agreement with Seqwater called an access permit, so similar type of thing to a lease or a license, and said that we've complied with all our obligations under that, so we're entitled to access. They also said that whether or not that's correct, we have residual rights under the Telecommunications Act, which allow us to go and access the premises, again, harking back to Christie's presentation, provided a relevant LAN has been served and the other requirements of the Act have been observed. Seqwater, for its part, said, well, no, you haven't complied with your obligations under the access permit, and therefore we are justified in refusing access to install your equipment. Now, a little bit of background. So prior to this case and prior to the entry into the access permit, Satellite had, in fact, tried to get into this facility and install its low impact facility by using its Schedule 3 powers and serving a LAN. That was the subject of separate litigation, and as the result of that litigation, this access permit was entered into by way of settlement of that earlier litigation. Now, just again to expand on that a little bit, and I think it's relevant to the outcome of the case, that in the background section of the access permit, the basis of the agreement was described, and the background was described as this: that Seqwater was had a reservoir tower, and it was subject to the requirements of the relevant Act, Queensland Act. As a public utility, it had to manage and build assets and lands in a sustainable manner to improve the catchment health and water quality for Brisbane. It also had statutory obligations to provide safe, secure, resilient and reliable bulk drinking water for the general public. That the area in which this low impact facility was going to be constructed was located within a key operational and or catchment area of Seqwater, which operated a 24-hour-a-day facility on the land. There was a chemical dosing facility on the land as well. So significant public infrastructure, and this is important, the carrier had agreed to the conditions set out in the permit for the carrier to have access to and non-exclusive use of the permitted area for the permitted use and for the subsequent removal of the carrier's equipment. And again, you'll recall from Christie's presentation that what happens at the end of the lease or license is a very important part of any negotiation. So against that background, the case was fought, and what Seqwater said was that the access permit governed the entitlement of satellite to the exclusion of the operation of the Telecommunications Act. In other words, Schedule 3 of the Telecommunications Act didn't matter anymore. The only rights that satellite had in order to install its low impact facility was contained in the access permit. And they said that this was the case because under clause 11 of Schedule 3, it provides that a carrier must make reasonable efforts to enter into an agreement with a public utility that makes provision for the manner in which the carrier will engage in an activity. Then there are some subclauses. Then importantly, subclause 2 of clause 11 says a carrier must comply with an agreement in force under subclause 1. Now, the court looked at that and said, well, what this means is that because the terms of clause 11 are mandatory, using the word must, it means that once you enter into an agreement with a public utility, the right of access is governed by the access permit. And the only source of any entitlement to install the low impact facility is what is contained in the access permit. Now, there were extensive provisions in the access permit about what what satellite had to do, and the court said that it's plain from the evidence that even the application, that the request for access had been requested pursuant to the terms of the access permit and not pursuant to any LAN. So that's another reason for taking it outside the Telecommunications Act. And the court held that in its view, Seqwater was entitled under the terms of the access permit to refuse the applicant access, that's satellite, access to the reservoir tower in respect of all the requests it made. And it found that because on the evidence, again, the requests were non-compliant with the access permit, with the strict conditions in the access permit for access to install its facilities. And the court, and again, this harks back, I think, to the character of the landowner and what was said in the background to the access permit. The court said that the respondent, that's Seqwater, operates a major public utility in Queensland with critical risks referable to public health and safety. So, in those circumstances, the court was prepared, and this is the Federal Court, I should say. I didn't mention that earlier. This is the Federal Court of Australia, not the Supreme Court of Queensland, so it has wide application. That was obviously that public health and safety consideration was clearly important, and the court went on to say the applicant, that's satellite, does not have a residual right of access for inspection or installation purposes, or to engage in such activity as usage of power supplies of the respondent under Schedule 3 to the Telco Act. So you might, harking back to NBN and Pipe Networks, where Pipe Networks wanted to use the power supply. In this case, this 2021 case, Federal Court said, because you're governed by the access permit, by the consensual agreement, you don't have those Schedule 3 rights under Clause 6 or 7 that might otherwise allow you to use power supplies of Seqwater. And the court, of course, was taken to NBNco and Pipe Networks, but it distinguished it and said it's of no relevance in circumstances where in NBNco they hadn't entered into any kind of agreement, whereas here it's governed by an agreement. So clearly the significance of entering into an agreement is something that any landowner needs to bear in mind as critical, but also, and you have to do a bit of a balancing act, I think, in terms of making sure that in your insistence on clauses that are protective of the landowner's rights, you don't get to a point where the carrier says, well, we can't reach agreement, so we're just going to rely on our Schedule 3 rights. Difficult exercise, but nonetheless one that is critical. So those are the two questions, the two cases that I wanted to discuss with you today. So we are now up to the part of our webinar where you get the opportunity to ask Christy and myself some questions. So just looking to see whether we've got any questions that have come through. Oh, sorry, get that out of the way. So yes, sorry, back to questions. Now, one question, Christy, if I can, if you can answer this question, in your experience in dealing with these telecommunications leases, how willing are the carriers to negotiate?
That's the big question, David. I mean, they all have these, their preferred standard template documents that they like to work from, and in a lot of instances, that's the document that the parties are working from as a starting point. That often makes it very difficult to negotiate any amendments or any meaningful or substantial amendments because the document's already drafted in a way that the telco is comfortable with and that caters for their every desire. I mean, they can sometimes be quite reasonable for things that are clearly very important to a landowner, but a carrier could perhaps budge on a little bit. But it's difficult to get clauses completely out or amended in a significant way that are things that I guess a telco would consider a deal breaker. So some of the things that I touched on, for example, the ability to assign a lease without landowner's consent often can't be amended. The ability to terminate if the facility is no longer required by the carrier, or if there's some interference from another subsequent occupant. These things are really difficult to have deleted, but there is instances where we've managed to have the clauses amended so that they're a little bit more user-friendly for a landowner and a little bit more balanced for both parties.
Thanks, Christy. Supplementary question. Do you find there's any difference when carriers are negotiating with a private landowner as opposed to a public landowner, like a public utility or perhaps a council?
I think, unfortunately, in most circumstances, the telecommunications carrier has a superior bargaining position, whether they're dealing with a private landowner or with a more public type landowner like a council. I think a council or more public type landowner is obviously much better equipped to deal with this situation, perhaps because they've had encounters with carriers in the past and they've got experience with negotiating these sorts of deals. So they're a little bit more aware of what potential issues there are and what to look out for, and therefore what sort of a bargaining position they can take. Yeah, I think it's difficult either way, regardless of who the landowner is, but councils and more public landowners may have a bit of a better bargaining position.
Okay, thanks, Christy. I suppose you would expect that, given their position, and just harking back to the South East Queensland water case, which of course is a public utility and has the benefit of clause 11 of the schedule, which is expressly relates to public utilities. So, okay, thank you. Now, just looking here at other questions. So here's another question: if the carrier enters the land under using Schedule 3 powers, does the carrier then have to pay rent? Christy?
So the answer, unfortunately, is no, they do not, and that is the major drawback of a situation where a carrier does elect to rely on its Schedule 3 rights, and is why a landowner should be as commercial and reasonable as possible when looking to enter into a lease agreement with a carrier. So at least under that sort of arrangement, the landowner will be entitled to some sort of rental payment, although carriers will use their bargaining position to put a damper on the amount of rent that's payable. Sorry, I've just lost my train of thought. So yeah, you don't really want to be in a situation where the Schedule 3 powers are enacted and you therefore miss out on your rent, and then you're relying on very limited opportunities to claim compensation under clauses 42 and 62 of the Act, which are really just, like you mentioned in your presentation, things like where there's been damage to property or where the land has effectively been acquired. But yeah, it's much better to have some sort of agreement in place where you're receiving some sort of rent.
Okay, thank you, Chrissy. Yes, at clause 42, whilst there's some comfort there, it's not the same as getting a good steady flow of income from an agreed rent. Coming out the other end, so talking about exiting rather than entry, question from our audience: how easy is it for telcos to engage the exit clauses in their lease and uplift their infrastructure to another site?
Taking into consideration some of the clauses that I covered in my presentation, there are always clauses that telcos like to have in their leases which do give them these outs. One of the main ones is if they no longer require the facility as part of their network, or if there's some interference from another occupant. I mean, it really depends on the specific wording of the clause and the factual scenario about whether the circumstances set out in the clause have been met, and therefore whether the telco can rely on its termination rights.
Okay, thank you. So again, go back to that, back to the lease, and that's where the genesis of it all is. Quick question for me, I think. Does the court interpret the powers under Schedule 3 strictly? Okay, well, the usual tenets of statutory interpretation apply, but I guess having regard to the extensive powers under Schedule 3, the courts do tend to look at interpretation in that context. So, for example, in the NBN case, Justice Kuntz quoted with approval the judgment of the New South Wales Court of Appeal in the Hurstville Council case from much earlier, which in turn had quoted from a 1994 High Court case to say that statutory authority to engage in what otherwise would be tortious conduct, and otherwise be trespass if they didn't have these rights under Schedule 3, if they go in without consent. Statutory authority to engage in what otherwise would be tortious conduct must be clearly expressed in unmistakable and unambiguous language. So the court is sending the message that you have these wide powers, but we're going to make sure that you use them within the bounds of those statutory provisions and not allow a loose interpretation. Okay, Christy, I think probably another one for you. How often do private landowners obtain legal representation in your experience?
I mean, well, that's difficult to say. I know we often get a lot of councils and more public type landowners coming to us for advice. Private landowners too. I can't say how many, how often, but I don't think it's a bad idea. And I think that's because, you know, for example, the waiver of notice clause that I spoke about, the last point 8 of my presentation, seems very unassuming at first glance, but when you consider the that it can have ongoing effect after the end of the lease, I think that some may not appreciate that and the impacts that it might have going on into the future. So it can, I mean, obviously lawyers cost money, but I think it can really be beneficial to get some legal advice. And telcos will often make a contribution to the landowner's costs of obtaining that advice. So they are quite often good in that way.
Okay, well, it's very handy to know. Now I see the time, and we're coming up towards where we need to wrap up today's session. Perhaps one last question, certainly an interesting one to finish with. Does anything in the lease cover the point of radiation and any effects on people claiming for damages caused by radiation and electrical wave from the carrier's equipment? Is that something that would ordinarily be covered by the lease, Christy?
Well, there's certainly a clause in the lease which says that the carrier has to comply with all laws. So that would include, and that should be an expansive definition of laws to include all regulations and codes of conduct and things along those lines. So I think there would be, if the carrier were to breach such laws, which would also include, you know, radiation and electromagnetic activities and the damages that they may cause, a breach of those laws would therefore be a breach of the lease, and the lease would include some sort of indemnity about that the indemnity and release clauses, so that the landlord should be able to rely on to have its cost of breach covered, and that that they can't be held accountable for breaches of the carrier in that regard. So I think that would probably cover it off, but those indemnity and release clauses should be looked at carefully.
Okay, thank you, Christine. I suppose the other part of that is you may have some common law rights if you can prove that the radiation or the electrical wave activity has actually caused some damage. Well, ladies and gentlemen, that I think brings us to the end of our presentation today. Thank you for attending today's webinar. Once you leave, you'll receive a short survey on the presentation, and we would very much appreciate it if you would provide your feedback. You'll also receive a follow-up email with a link to a recording of today's webinar, along with the slides. And you'll see on the screen there the email addresses for myself and Christy. If you have any further questions, please don't hesitate to send them through to us. So on behalf of Bardia Perry, thank you for joining us today, and stay safe and dry.